Welcome to Protect What Matters, Estate and Elder Law with Tim Murray.
Welcome back to Protect What Matters, Estate and Elder Law with Tim Murray, a Winamac lawyer in Indiana. Tim has more than 35 years of experience helping Indiana families with estate planning. That probate and elder law matters as well. I'm Evan Mack, and today we're talking about how to keep your estate out of court and out of conflict by making sure your wishes are clear, your paperwork is current, and your family isn't left guessing what matters when it matters most. Tim, welcome back, sir.
Thanks, Evan. Always a pleasure.
Pleasure's all mine. Tim, what does it actually take to keep that estate out of courts in Indiana?
Well, there's different levels of planning that we can use. I think a lot of people have heard about payable on death, transfer on death, a beneficiary designation in an IRA or in a life insurance policy. Those things are what we call non-probate transfers. If you have a savings account, and let's say I put my daughter Mary on as payable on death, she doesn't own the account with me, but when I die, she shows up at the bank with a death certificate, and they're going to give her all the money because it pays on death to her. So that's one way to avoid probate. I don't always recommend that because it doesn't have any planning in place. It's just, we call it like a document that just gets a result. What if Mary has some issues in life? What if Mary died before I did and I don't change that? And now her 12-year-old daughter is going to get all the money in that account because it would go to lineal descendants if I don't have a will in place and things like that. So it can be fraught with some problems. Transfer on death is another way you can do it. You can do a deed that says from Tim Murray to Tim Murray. Transfer on death to my 5 kids. And when I die, one of them can step in and do a 2-page affidavit that gets recorded. And now my 5 kids own my house. And that's a non-probate transfer. Non-probate means it does not go through the courts, doesn't go through the probate. Okay, I'm sitting in Winamac, Indiana right now. And when I'm doing this, I'm pointing towards our courthouse, which is right that way across the street from me. I'm in the habit of doing that when I'm talking. That's where we do all the in the Justice Center. That's where we do all our court probate matters. So those are non-probate transfers. They can be used to facilitate and do some cool things. But again, they don't have the kind of planning that we always want to see for people that might take care of some things. One of my most favorite, coolest things to do, if it's the right fit for people, is to have a trust. A trust is a way to own assets, have assets pay to that trust, and have it administered and not go through the probate process. It doesn't go through the court process. So when I die, I may have a savings account again. Instead of having it payable on death to Mary, it pays on death to my trust. So my trust would then say, take any money that's in here, take any property that's in here, cash it out, and start passing things out to the people that Tim Murray designated as his beneficiaries of the trust. And that can be anyone. Well, let's just say it's my 5 kids. So it'll start passing out and making distribution to the 5 kids. It could be to charities. It can be, hey, I don't want to give all my money away. I want to put something away in what we call a separate share trust, so that maybe my grandkids can benefit from that. And I put something away for their college, or I can direct it into a 529 plan. And I'm not going to explain all those things to you, but people who have heard of those things will know what that means. It's a savings account for college for people and kids. So you can do so many cool things with a trust and not have any of your assets go through probate, or very few, if any. One thing I always want to let people know in Indiana, under Indiana law, is that when people die, Indiana law says if your gross estate minus your debts, liens and encumbrances is how it's worded. So like a mortgage or credit card, things like that, minus your debts. If it's over $100,000, then you're required to go through probate. If it's under $100,000, you're not required to go through probate. You can transfer your assets by other methods, small states affidavits, spreading the will of record. You can do some things like that. So I think people should realize that. And sometimes we plan accordingly. So if we have assets and maybe you have $700,000 in assets. And I have a lot of people who want to avoid probate. I mean, probate's not a bad word, but people just don't want to go through the courts, and they don't want to expose to, and it's not private, it's public records, things like that. Then you can set things up to where it would all pay or go through a trust or pay on death to your beneficiaries and not have to use the courts in the probate process. And a will, hopefully, I think everybody should have a will in place, no matter what your planning is. Everyone needs a will. And so those are the processes to take care of. Otherwise, you're going to leave everything up to Indiana law. Now, I always I do my estate planning workshops, and I've mentioned them on previous podcasts that you've done for me, Evan, and I do estate planning workshops to educate people and show them the things that can and can't be done. Part of the workshop is what happens when you die and you don't have anything in place. But before that, I always ask people, hey, anybody in this room have an estate plan in place? And most of the time, nobody raises their hand. Maybe one or two already have a will done and they want to come to me and get it updated. But I always have to tell people, you do have an estate plan in place. When you turned 18 years old, the laws of the state of Indiana put an estate plan in place for you.
Wow.
And I bet nobody, since you don't have one, nobody knows what that plan is. And once I usually explain the law of that plan to people, they don't hardly ever want it to work out the way Indiana law wants to take care of their assets and what they own. So we're pretty quick to get into some estate planning. And it's not that they don't have one. Indiana law just dictates what it's going to be. And it hardly ever works out the way people want it to be if they leave it up to that.
So Tim, what are the main reasons an estate ends up in court, though, in the first place, based on everything you're saying? Is it usually that missing documents, like unclear instructions, family disputes? What have you seen in your experience?
I got to say all the above. There could be family disputes. There can be unclear documents. We can have, I had one last year that I think this is a great example to show someone whose estate was worth less than $100,000, but we chose to go through the probate process anyway, because it was a better way to clean up his estate and the mess that was left behind. So this gentleman, he was never married, didn't have any kids, but his dad had been married twice, and between the two wives had like 16 kids. Okay.
Wow.
Yeah. Okay. Let alone two wives, right? So anyway, hush, Murray. Anyway, 9 kids with the first wife and 6 or 7 kids with the second wife. And this guy dies. Okay. And he owns a house that's worth about $60,000, and he had a pickup truck that was worth about $6,000, and he had about $3,000 in the bank. So he's under the $100,000 limit in Indiana. He had no debt, no mortgage, no debt of any kind. We could have tracked down, if he had 1 or 2 brothers and sisters, we could have tracked down those people and passed things out and never had to go through probate, using some different tools. But because we had 16 brothers and sisters, 6 of whom had already died. Now, the brothers and sisters that died, they had kids. So each one of their shares goes on down the line to their kids. So we ended up having, I think all totaled, once we did all our research and investigation, we had over 30 or 37 people that we were going to have to pass on this property to. If we didn't go through probate, we could have just done a title passage affidavit, and you'd have had 37 different people from all over the country on a deed to a property. So how efficient is that, and how easy is that going to be to sell and have everybody sign off? So we chose, and I advised, the guy's sister stepped up to the plate, and we opened up an estate so she could manage and take care of everything. She could sell the house, sell the truck, take care of everything. One person taking care of everything in a more efficient manner. We reduced everything to cash. And then we had cash and checks that we could just send out to all those people. 4 of them we could never find. We didn't know who they were. So what do you do with that money? I get an order from the court that says their money is going to be deposited in our local clerk's office. If they ever show up, they can get it from our local clerk's office. That's one of the messes, I guess, to show you how things can be. And all the guy had to do was, a couple of easy planning documents would have taken care of all that. He could have done a transfer on death deed to his sister on his house. He could have had transfer on death on his car title. He should have had a will. Forget the transfer on death stuff. And this is all just a few hundreds of dollars. He could have had this taken care of. Instead, it cost him, and through the estate, several $1,000s to get it taken care of. So, and a lot of pain and anguish for the family and the sister and things to go through. So, yeah, that's just one example of how things can go awry. So just planning and putting things in place, even simple things, can save the day.
So, so Tim, you've been at this for a while, many years, and what kind of problems do you often see when people go through that? The generic forms or the DIY forms or the online kind of estate planning tools.
Yeah, boy, I love that. So, I guess maybe as I get older, I'm less patient with people. I don't know what it's like. Sometimes I have to. I just look at people across my boardroom table, and I have a bit of a smart aleck attitude sometimes, I got to admit. And I just tell people, don't let your Google search get in the way of my law degree. And I don't mean to be arrogant and egotistical, but I literally have people that have downloaded a document. They will come in to see me and ask me if I will review that document and if it's okay, so they can just go out and use it. Now, in case you weren't tracking all this, they're not wanting to pay me to do anything. They just want me to tell them that the document that they downloaded off the internet is good and legal, so they don't have to come in and pay me to do something for them. I've had people do that several times. But the problem, the first issue is going online and Google. I mean, it's a blessing and a curse. What a wonderful tool we have. And now with AI, I mean, holy cow, the things that you can do and look into and the parameters you can set. But the problem is this. I get people who come in and they're like, why should I pay you if I can just download it and do this? Or the things I have to fix. First of all, is it an Indiana specific document? Because I can guarantee you the same type of document that's used in California isn't going to work in Indiana. Right. We don't have the same laws. Or Louisiana and Hawaii are in completely different, legal systems, so to speak, than what we are. They're we were under the old English law, and Louisiana's under the old French law, and Hawaii is under, I can't remember how theirs is, but anyway, King Kamehameha, something like that. So anyway, the whole thing is you're online, you don't know where these documents are coming from and what state they really apply to. So that's the number one thing you have to be careful of. Proper execution. If a document's not properly executed, it's worthless. I've had wills come in that they've downloaded and done themselves, and I'm just like, well, this would be fine, except it's not properly executed. So what do you mean? Well, it's not going to work, So, so it can be fraught with problems. Am I opposed to do-it-yourself work? Heck no. I mean, but it's tough to want to say go out and do it yourself when I think one of the benefits that estate planning lawyers offer is that we can talk you through it. We can explain things to you. We can tell you how these documents are going to work, how they're not going to work. We can tell you how, what kind of customization and things you need to be aware of, how things are, a state of Indiana form is better than nothing at all. But I would much rather have you come in and talk to me about how can we take that and customize it and make it more powerful, give it more meaning. One of the things we're running into, I haven't had it yet, maybe once, I think once a few months ago, but I've spoken with other attorneys that have run into a situation where some institutions, banks, insurance companies, will not recognize a power of attorney document that might have been executed 6 or 8 years ago. Wow. Now Indiana law says it's good forever, but they want to see a more current document. They want now they can get in trouble, and there's a law that says if you refuse someone the use of their POA, that you can be subject to treble damages and things like that. But the fact of the matter is something when banks or places act like this, something had to have happened. So I'm guessing somebody had to have something happened, and they got on the short end of the stick, meaning they got sued over it for them to change their policy. So somebody probably had a POA from 10 years ago, and I got ticked off at that person. So I named somebody else a year ago.
Yeah.
But that person from 10 years ago is still using their POA to maybe take money and write a check and withdraw funds out of my bank. What's the bank know? And so they allowed that to happen. My new POA finds out about it, and maybe there was a lawsuit that was struck up because of that. That's just one possible explanation as to why they do those things. Sometimes they want one within the last 6 months that's certified, that you want to have a certification stamp on it. So there's issues like that can come up. So we want to keep things current. We want to keep things up to date. And when I hear about things that are happening in people's lives, maybe the Veterans Administration won't recognize a power of attorney because it doesn't have specific language in it that says this person can handle military and Veterans Administration issues for Tim Murray. I mean, I'm not a veteran. I apologize to the veterans for that. But I've had people that were rejected and couldn't use their POA. So what's little Timmy do? Every one of his POAs has a paragraph. You can do VA things, and they can do military things, and whatever has to happen. So that's the kind of customization and good things you get. That's not in a form offline. You'll never get that. But those are the kind of things that lawyers who are in tune to these things, and I think stay on top of the issues, are putting into their documents and keeping them current and workable for their clients.
Tim, as an estate planner, you've probably seen how small disagreements can spiral. What tends to calm things down when families start to disagree about an estate?
I think the best things to do are to have communication and transparency in your information and what's going on. I think from what I see, most of the time there's already some kind of rub between a brother and a sister, or an aunt and a nephew. There's usually something going on already anyway that just creates more heat, right? So what we want to do is look, I got to follow the guy's will or his trust in Indiana law. It's not like I'm going to be encourage anybody to steal or take advantage of, or that's not how I operate. In fact, I get a little anal and overprotective about estates and trust administration and probate. We run a tight ship because we are messing with people's money and assets. So to have community, even with the people who are the most dysfunctional and the problem and the biggest pain in the rear ends that are in the whole mess, we still want to maintain open communication and information exchange as much as we can. And that just answers their questions and puts all those arguments at bay. Well, I haven't heard from you for 2 months and I don't know what's going on. Well, we've sent you 6 emails, in response to that. Either we've not done our job and we pick up the ball and we're going to do it and do a better job, and we assure them and we get them all the information. Or we can point out, we've sent you 6 emails in the past 2 months. My legal assistant who handles that estate has called you 3 times and you've not responded. So that's when I get to say, don't sit there and tell me we've not tried to communicate with you. Okay. I can prove that we have. And so and sometimes I have to be a little more firm with someone, than I'd like to be, but I don't ever do it unless, I do the Rambo thing. They draw first blood. So, but I just want to always be compassionate. Someone died, and it creates a world of emotions and feelings, and who knows, and strife many times. So I just want to do everything we can to help the conflicting people and all the people involved get through this as best we can.
Well said. And for anyone listening who hasn't done any of this planning yet, Tim, what's the simplest way to start protecting their family to avoid those problems later on?
see one of my workshops. I think, come to one of my workshops and start getting involved in the process, or you can watch one online on my website. And we have it's getting some age on it, but the stories and the applications are still the same. Go to an attorney if you're not in our area or can't make it, to my office for some reason. Go to an attorney who has a good reputation for this kind of thing, and start the process. Get an education on this, and I don't necessarily mean go online. You can do some reading and research, and that's great, but you need to talk to someone who knows, who's been in the business a while, or has an associate that is doing this now, and they've talk to even a younger lawyer who's doing this now. But just start the process. Go see an attorney and get the process going. You'll find that, we're all, usually pretty good people to talk to and work with and learn from. It's a learning curve and a learning. I think one of the biggest things that I see is a person or a couple who comes into my office and we just want to get wills done. They've not seen my workshop, number one, and I always encourage them to see my workshop. You get to come and see me for free after the workshop because of watching the workshop. But I have some people who don't want to do that. They just want to get a new will done. So they have to come in and they pay a consultation fee. And by the end of I usually don't sit with people more than an hour and 15 minutes, because I start rolling up in the back of their head and they glaze over, and I don't want to lose them. It's not that anything's particularly hard. There's just a lot of it. So, right. But without fail, they'll get up and they'll walk out of my office scratching their head and they'll be like, wow, I never realized there was so much to have to consider and so many things that have to be thought about and thought through to take care of, when I just walked in there thinking I'll just do a will. This is not mom and dad or grandma and grandpa's estate planning from 40, 50 years ago. It's a different day, and things have to be handled in a much better and more educated way. So.
Good stuff, Tim. Appreciate you.
Thank you.
Alrighty, guys. That's it for today's episode of Protect What Matters, Estate and Elder Law with Tim Murray, a Winamac lawyer in Indiana. If you'd like to learn more about estate planning, wills, or trust in Indiana, visit tmurraylaw.com or call that number 574-946-7819. Thanks for listening. And don't forget to subscribe, share, leave a review if you found this episode helpful. Thank you very much. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.